everyone, and welcome to Tech Me Up, the International AI webinar series by Taylor Wessing. We want to thank you very much for joining this session. It's session 3 in the webinar series about AI and liability. And I want to start off with a quote from Oren Etzoni. He's ex-CEO of Allen Institute, a renowned non-profit research institute on high-impact artificial intelligence. And he said, AI is neither good nor evil. It's a tool. It's a technology for us to use. You may also want to call it a product. And like a hammer, I can use it to smash a nail into the wall and hit my hand rather than the nail's head. That's my own fault, and not too many consequences are attached to it. But what if the tool is much more complex? What if it's not tangible? If it is software entailing certain functionalities beyond predetermination, or which makes decisions we cannot fully comprehend at first sight? What if such a tool is created and used by a variety of stakeholders? If it's widely used in real life applications, in business use cases, and if something goes wrong? What if the tool is artificial intelligence software and something goes wrong? We want to take a look at that in the next 45 minutes. And for that, we assembled a lovely panel, which I would like to introduce to you first, and then give a quick look at what we're going to talk about. First of all, we have Travis Norton on board. He is with Bureau Veritas and has been with Bureau Veritas for more than 20 years. It's a leading testing, inspection, and certification company. It supports its customers throughout the entire life cycle of their facilities, products, and infrastructures, helping them to ensure quality, reduce costs, increase productivity, and promote a responsible, sustainable corporate culture. He's director of global technical services, so he leads and manages a technical consultation team that covers certification and testing of like smart homes, smart wearables, connected consumer IoT devices. And he's also an ASTM member, participating in various committees such as for unmanned aircraft systems, for security systems, smart textiles, and he's also a chair for connected consumer devices. And we're really happy to have him on board because he will bring the very important technical and certification aspects into our discussion round. Next, I want to welcome Katie Chandler, who is a lawyer at Taylor Wessing and leads our product liability and product safety team in the UK. She's a litigator with broad experience in the technology, life science, automotive, and consumer product sectors. She specializes in guiding clients through high-value contractual insurance claims and technology disputes and defense of product liability litigation. And Katie also regularly works with clients in the technology sector and has particular expertise advising companies involved in emerging technologies, such as AI, automated vehicles, 3D printing, and Internet of Things on liability and regulatory issues. So she's the perfect match to bring in the legal perspective, especially also from a UK perspective. And last but not least, I want to introduce Philipp Behrendt. He's a partner at Taylor Wessing Hamburg's office, heads up the German Disputes and Investigations Group of Taylor Wessing, and is also joint head of the international group. And he too conducts complex proceedings before state courts in Germany, and a focus of his practice is product liability, product safety law, in which he advises on the marketability of products, recalls, defense claims, and all other related aspects. So thanks, guys, for making it to the panel. Looking forward to discussing with you. And what we're going to talk about, I just want to briefly put up beforehand, and we'll dive right into it. So what we want to do is we want to set the scene first. We want to talk about AI as a tool or product, what new risks arise from it. Is there the current regime, is it like fit for purpose already? Where does AI liability fit in that regard? And we also want to discuss new liability questions that arise in implementing and impacting AI in real life scenarios. Then we will focus, like as a second pillar, on the emerging liability frameworks in the EU, UK, and the US. Talk a bit about the PLD and the AI liability directive, especially what's happening also in the UK, and take a look on the US landscape. And once we set that as a basis, so to say, in the third pillar, we'll discuss specific use cases or case studies. How does this all apply in practice when AI and approach go wrong? And have a bit of a rather, I would say, discussion round rather than just focus on 10 minutes presentations, but rather like have it a bit more in a discussion format, and looking forward to that. So 2 more organizational points. We will be very happy and comments during the session, and we will collect them and we'll reach out to you after the session. And you will also receive the slides afterwards. So now that we have that, I would like to give way to the actual part of the introduction and look forward to a very interesting seminar. Thank you.
So thank you, Fritz. I think one of the first things, just to get everybody grounded is to understand, what's different about AI and what are some of the risks that we see. Certainly there's a level of complexity that's different even from normal programmable devices or systems. Part of that being, does the user understand? The example you gave of using a hammer, it's fairly apparent to the average user, which end to hold and which end to strike. When you're dealing with a device that has machine learning or artificial intelligence algorithms, it's a bit different. The interactions and the way consumers interact with it may be quite different in terms of what the expectation is, or even how it can be used or applied. There's this phenomena kind of known as the black box, where the evolution or iterations of the development of an algorithm are based on the output performance, meaning that imagine the sort of generations of them are created. They select the best one, which is then used and creates another variation. So as you go through potentially millions of these variations, you get to something that works really well, but you don't know why it works. And even the programmers in many cases will tell you, we're not really sure exactly why it works, but this is the best performing one. So it has this black box phenomena that's challenged. Obviously, openness and security applies to any kind of connected product, but it may be even more challenging where we don't really know why it's working or how it's working or how it could be disruptive. Also, it has autonomous behavior and it's continuously learning. So these are really unique. Some robotics may have autonomous behavior, but they may not be adapting and learning as they go along. Predictability is a challenge, partly because these things are data driven, and the data models that are set up, or the data sources that are being used, it's enormous amounts of information that cannot always be scrubbed. And there may be some variables within that data that give rise to anomalies in the behavior. Even vulnerability or to security, cybersecurity issues, or inadequate safety measures, will also give rise to unique phenomena because of the autonomous and adaptive nature of these products, that there's often inadequate assessments of the training data with respect to real world scenarios. So in many cases, what we've seen in testing and certification is there's been a really focused effort on what I want it to do in the intended use scenario, but there's a lot of unforeseen activities that occur in foreseeable use conditions.
Many thanks.
And
play into the potentially outdated regime.
Sure, happy to do so. And it's very interesting to see what Travis described on what is happening in terms of development of AI and how that fits into the existing regime, in particular when you think about product liability regimes, which have a very similar basis in most jurisdictions worldwide. The basis is probably that product liability regimes impose a form of strict liability, so non-fault based liability, first of all, but it affects products being typically tangible products that you use and do something, like cars, like bicycles, like medical products, whatever. These tangible products are, as opposed to AI, brought to market at a certain point in time, and typically will not change after that point in time. So already that is a very significant difference to what's been seen, what Travis just described for AI-driven products, who will continue to learn and will need to adapt the legal system to cope with these challenges. Another legal challenge is that damages have been focused on damage to personal health, life, to property in other things than the product itself. But now by software in general and AI more specifically being becoming more relevant in the market, things like data integrity, cybersecurity, etc., becomes much more relevant, and the question arises whether that is something where someone needs to face liability as well. Uncertainty and unpredictability is a huge issue which does not fit well into the existing product liability regime, because even though it is a non-fault based system, a claimant still has to prove causation and basically has to demonstrate how a product caused a potential damage, an actual damage. And that is very difficult when you do not know what an artificial intelligence has actually done and how it came to a conclusion and how it executed a certain act. So all these are issues which have not really been addressed in the existing product liability regime, and that is true, as far as I can see, more or less in every jurisdiction. So that leads to desire to look into that regime, and we can switch to the next slide to see how there will be changes and what changes will be necessary. We'll come to that in a little bit more detail in a minute, but very broadly, we see currently in the European Union level a very intense discussion on updating product liability and product safety rules. That led already to the revision of the old General Product Safety Regulation and the introduction of the General Product Safety Directive, which includes rules for self-learning, for software, for self-learning devices, etc. as well. Product Safety Directive defines that a product needs to be safe and when it's considered to be safe, etc. Corresponding to that, there is currently discussion on the way on an update of the Product Liability Directive. The Product Liability Directive addresses liability when an unsafe product has caused harm. So that, at least as the proposal stands now, is going to include liability for software, which is new. Is going to include liability for data loss and data corruption, and there's certain other issues we'll address in a minute also. And third, we see the introduction of a specific AI liability directive, which comes together with the AI Act, which defines transparency rules, safety standards for AI more general, and the AI liability directive then again defines liability, similar to the product liability directive, but gives a framework for fault-based liability directives, so outside the product liability directive in all European Union member states. That is the EU standard, and probably fair to say that from a legislative approach, the EU is probably relatively far. US and UK are adopting different approaches, and probably address that in a minute as well. So, but that is what's being planned at the European Union.
Thank you, Philip. We'll get into that a bit deeper in a few moments. But based on what we've already heard, Katie, can you just give us a quick info about what may be new liability questions that arise that would also justify new legislation and how to treat new use cases in that regard?
Yes, absolutely. I mean, as Philip said, the strict liability regime and the traditional framework that we have is quite straightforward. It determines where a product is defective or has had a malfunction, has caused some sort of injury or physical harm to the end user, and it is reasonably straightforward in terms of trying to establish, whether that was caused by the product itself and the manufacturer. With AI-enabled products and products where you are using software embedded and you are, potentially having them operated by some sort of AI system, it opens up a whole raft of new liability questions. And we'll come on shortly to talk about some use cases where, that might operate in practice. But you've got things like a person operating a technology that carries an increased risk of harm to others because you might have, a semi-autonomous or some sort of automated driven transportation in a public space, so that immediately increases the risk of harm to others. not necessarily just an end user. Who's liable there? Is it the operator? Is it the manufacturer? Is it the software developer? You might have a service provider who has more control over that particular product or service that's with AI, and where does that come into play in terms of who's responsible for software updates and particular failures to maintain that software, and an operator who's using it, as I said, with some sort of autonomy or more control over the decision making than you would otherwise be used to. When is that liability passed from the operator to the manufacturer and the software developer? Who ultimately is responsible for that? And then another really important issue is that manufacture of these sort of products incorporating tech, there is a real risk that they will change once they've come to market. So the safety conformity assessment, usually takes place where, the product gets assessed and is placed on the market. It stays in that current state. Here you've got a completely different scenario. And as Travis has said, it's continuously adapted. It continuously learns. It can be integrated into different products. There'll be updates, upgrades. There'll be some market alteration, some of which manufacturers and software developers and operators might not even know about. Then you've got the consumer use and the way in which the machine might change as a result of consumer learning. And so it's really unclear as to how these sort of liability questions will be handled. And under the current regime, certainly insofar as the EU and the UK is concerned, it is far from clear that we have a satisfactory framework that can actually give recourse to consumers and in fact give manufacturers and those involved in the supply chain the sort of clarity that they need in terms of understanding what that liability framework looks like.
Thank you very much. I think that is a perfect step to ask, how will this new framework look like, and will it be able to really tackle those problems sufficiently? So we want to take a look at the EU, UK, and the US liability framework to just get a glimpse of that, and looking forward to hearing from you first, Philip.
Sure, happy to kick that off. Well, I mean, probably an answer to your question really in the beginning. I think we will face a number of questions and issues we cannot really predict now. So we will see a continuously developing legal framework over the next years and probably even decades. So we will need to keep adapting the legal framework to the changing reality. But I think also as an answer, the current proposals being discussed will be a good basis for the required changes. So if you look at the proposed new product liability directive, and need to stress it's still a proposal, it's not yet in a final form. We'll need to see what changes there will be, but if you hear and read between the lines, it's very likely to become law more or less unchanged. First of all, the first major change is that software will be a product, will be regarded as a product, which hasn't been the case under the old product liability regime. And software obviously includes normal software and artificial intelligence. What has always been the case is that embedded software, so for example, software you use in a car, was covered in the sense that the car is still a product, and if the software in the car caused an accident, there may be product liability claims against the car manufacturer. So they can be asked the question, how relevant is the inclusion of AI in software? It becomes very relevant when you look at what I just mentioned already. The scope of potential damage claims is being extended as well, because it will, under the new regime, it will not only cover damage to bodily harm, etc., but also damages caused by loss or corruption of data. So that is a very significant change. What we will see also is a change in the burden of proof, and there is some room for discussion still in how that will play out, and there will certainly be room for court assessment of these provisions, but in a very broad and very general sense, you can say as soon as the case becomes too complicated, the burden will shift to the manufacturer. You can certainly discuss whether that is appropriate, because in particular, when we look at AI, it is very difficult for the manufacturer also to demonstrate how the AI came to a conclusion and how it executed a certain action. But we will most likely face a presumption of causality in favor of the claimant in future cases when actually proving the causation is difficult. Another very relevant issue is that we will see much greater disclosure obligations. That is at least the case for most parts of Central Europe, mainland Europe, continental Europe. We know disclosure obligations already in most common law systems like the US, in the UK, or in Ireland, for example. But that is a very uncommon feature in continental Europe, in most continental European jurisdictions. So what that means is that a claimant will be able in product liability cases to demand disclosure of certain relevant material. That can be research and development documentation, can be correspondence about potential failures, can be assessment and correspondence regarding assessments at market entry level. So that can be quite a lot of material, and it can be very relevant to the case, and it can be potentially be very harmful. And that, again, is something we will need to look at how that will play out in future cases. If you come to the next slide, and briefly address the new AI liability directive. In short, what one could say is that the more procedural issues like causation and changing of the burden of proof and the issue of document disclosure, etc., will be for liability for fault-based claims brought in line with the non-fault-based product liability directive. So there will be a relatively similar regime under the proposed AI liability directive. The scope of that will probably be much more narrow because it will affect only non-contractual, non-product liability claims, but certainly we will see probably certain cases under the AI liability directive also in future.
That sounds great. Thank you. And keen to know if that really touches on the problems that we've found out that AI poses when it comes to liability. But first of all, what's happening in the UK, Katie, in this regard?
Yeah, so in the UK post-Brexit, none of the sort of proposed legislation that Philip has been discussing will be implemented in the UK. It remains relevant, of course, for those businesses who place products on the EU market, and global businesses, of course, will have to make sure that they are keeping up to date with the outcome of those developments. But the UK is itself looking at potential reforms, both in respect of the product safety regime and the product liability framework. But we don't quite know where that's going to go at the moment. Just actually 2 weeks ago, the regulator responsible for consumer products, at least the OPSS, released some proposals and reforms that they want to make in the context of product safety specifically. Now, not one that we're going to discuss in detail today, but that's more focused on how products are going to be assessed and which standards are going to be applied, and whether or not, in fact, the UK is radically proposing to sort of move away from the traditional conformity assessment process and having lots of different standards for different products, and potentially moving to a more hazard sort of risk-based approach, and potentially having much more of an overarching approach to those sorts of standards, particularly for consumer products that incorporate AI and other emerging tech. But generally on the liability framework, again, we know that they agree that definition of a product and whether or not software is included is not clear. Some inadequacies in relation to potential damage that can be recovered. Also, how do you deal with the different players in the supply chain now? All those sorts of questions they do seem to be aligned on, but they aren't taking the same approach as the EU, because we're not having, at the moment at least, a central legislation that's being considered like the AI Act in the EU and the AI Liability Directive and the wholesale amendments to the PLD. What the government here is saying is that they want existing regulators and legislation to be looked at, but with key sort of AI principles in mind, and essentially giving them the power to set some guidance, set some standards and some industry sort of best practice on how to actually deal with problems that will arise specifically in relation to AI. And so that's basically looking at the ICO, the CMA, the FCA and HSE and MHRA, and just telling them to set their own guidance, which is all very unhelpful, because it doesn't really mean that, you know, businesses know where they're coming from. They've set out some particular principles that are meant to go to the risks that Travis spoke about earlier that arise from AI, and we expect, you know, regulators at very different paces to publish some non-statutory guidance in due course. But as I say, a little bit of a wait and see at the moment. We do know that our Prime Minister announced that there's going to be a global AI summit hosted by the UK in the autumn. So that's a very interesting development. We are keen, as all the jurisdictions are, to support the innovation and to ensure that it doesn't, you know, any sort of regulatory or legal framework doesn't stifle that. So we will be interested to see, you know, whether there's any outcome of that and any change in the current position that the UK is adopting.
Very interesting, and it's also interesting to see that those two approaches are rather very different from each other, I would say. So also keen to understand, Travis, how that would look like from a US perspective, who's not known to regularly be a regulatory font country, let's put it this way. So let's see how that adds up to the first two invitations we just got. Thank you.
Sure, Fritz. It's definitely much more like what Katie was describing for the UK. I was thinking of it more in terms of the EU as prescriptive, whereas the US historically is reactive. But I like the way Katie phrased it as it's pro-innovation. You know, the idea being that you don't want to put too much regulation into something that could potentially hinder R&D or development or innovation in the market. And I think that's definitely the spirit in the US. But that doesn't mean that if something bad happens, that there wouldn't be some liability framework in place. You know, the CPSC, for example, has the Consumer Product Safety Act, which gives them the authority to recall a product, even if there's no specific regulation or safety standard that defines the nature of what a safe product is. You know, in some products that have been around for a long time, there are existing product safety rules that have been developed. Many of those give rise to voluntary standards, which are then adopted. In some cases, those voluntary standards are incorporated into regulation. But generally, it's a reactive mechanism. You know, when bad things happen, you know, it usually ratchets it up from white papers and guidance to a voluntary safety standard. And then more bad things happen, and it might actually get incorporated as a regulation. So that gives you kind of a sense of the landscape. Now, that doesn't mean that for example, the US federal government hasn't looked at this. The CPSC has published papers on artificial intelligence and machine learning to understand the risks and the issues that are out there. And there are some voluntary standards that I think give us some insight to the nature of how to address potential hazards with products that have autonomous functions. So, for example, some of these that you see listed here, like UL 3300, the IEC 30141, you know, these deal with robotics, and the nature of sort of some of these products on education or service robotics. The IEC standard actually deals with artificial intelligence and includes aspects for safety. You know, even within the United States, we have the NIST or NIST that publishes a number of guidance documents for the industry, and that includes a rigorous simulation of in-domain testing. You know, and when I talked about this at the beginning of the webinar, I talked about this challenge of intended use of the product is where a lot of the development and R&D and focus in manufacturing is, but it's really sometimes the foreseeable use. And what NIST is referring to, this rigorous simulation of, you know, sort of this in-field or in-domain testing that needs to happen. So these voluntary standards are a beginning in that direction. The one that I chair, which is listed here, is the ASTM F3463, was really developed broadly for just connected products in general, and take some of the best practices that apply, or even existing safety standards, and then apply them in a connected sense. So for example, in Europe, you have EN 71 for toys. We have ASTM F963. So it's a safe toy, looks at mechanical hazards and so forth. With the ASTM F3463, we're saying, okay, test it in a connected sense. Use the product in that when it's powered up. What happens if in the middle of a software update, you pull the plug on the modem? Or what happens if you power it off and turn it back on, or the modem's disconnected? So we look at these types of conditions to say, does it default back to a safe mode? And is it still compliant with the existing safety standard? So, I think this is pointing us in the direction where potentially voluntary standards might be able to help us understand how to address AI and product safety. I think we can define the nature of what is a hazard and from the existing safety standards, and then adapt those to these challenges that AI presents. But I still think there are some gaps. These foreseeable hazards that AI and machine learning introduce are not really specifically called out, in especially from a framework perspective. When you look at the insufficient user understanding that we talked about, I know what the hammer does, but I don't necessarily know how the AI works. The training data challenges, security issues, and then even how it differs from traditional approaches. This idea of data-driven decision-making, autonomous and adaptive functionality, these are things that are outside the scope of traditional safety standards, regulations, or even honestly, just industry best practices when we talk about safety assessments. So I still think there's a lot more to come in the future. And I think that as incidents occur in the real world, it will definitely help us to understand where to dial in, and where to focus on this going forward. But the existing legislative framework, similar to general product safety regulations in Europe, is the basic principle: if the product causes an injury, it could be subject to a recall, it could still be subject to liability, is there. But the point that Philip was making about this complexity of the multi-stakeholder, who's really responsible, is part of that challenge. In terms of what actually contributed to causality. Was it something in the chipset? Was it in the app? Was it in the cloud? Is it some combination between those, or something in the environment that triggered the hazard? This is going to be, in some cases, very challenging because it's not straightforward and simple like a hammer.
Understood. Many thanks. So I'd say that that we have a rapidly evolving, very complex technology that new risks, and it is subject to different regulatory standards that are also evolving. New liability cases may arise, and regulators approach it also differently from a statutory law or a voluntary code perspective. So maybe we want to try to give some examples to better comprehend how will this play out now and in the near future, and how does this all apply in practice. So when AI-enabled products go wrong, and to discuss that, we want to look at some case studies. And we have smart home products, connected toys, robotics, and diagnostics and imaging, self-driving and semi-autonomous transportation, where we may focus on some more than the others. But I'd like to open the discussion between you three now. Lead on the case studies, and then let the viewers know how this will actually play out in practice.
Great, thank you. So we've actually sort of bundled together connected products, robotics and AI systems, because they do share a lot of the similar characteristics and challenges and risks that we've been discussing. And so I think it is just quite good certainly when you're thinking about where liability is going to arise in relation to emerging tech products, that these are the key areas that are going to be of interest. So yeah, just taking, let's say, sort of smart home products and connected toys as examples, you've got a real growing interest and market for connected consumer goods. They're becoming more and more prevalent in our daily lives. You might see smart washing machines that are going to incorporate AI technology to improve the process. There'll be sensors to detect the volume, the weight, the fabric of the load. They can, give consumers options to handle it all remotely. Same with the smart kettle. We've obviously got lots of virtual assistants that are being used in the home. And there's obviously much debate around the security risk and the data issues that these products do pose, but that there are also potential safety risks. So if you look at connected toys as well, which again, one of the main concerns has been privacy protection, and particularly for minors. What about the fact that some of these are drones? They're interacting with other products. They're potentially going to cause harm, if put in the wrong hands. And where do the liability sort of issues arise? And so similar questions we've been discussing, because you're looking at potentially a number of different vendors might be liable. Questions you need to ask about sort of who's controlling the product. Where does the consumer come into all of this? Is there some sort of user error? Have they failed to follow instructions and warnings, which is what you usually see in the traditional products, and again is highly relevant when ascertaining liability under the existing product liability regime. Any sort of failure to warn by the manufacturer or inadequate instructions is always highly relevant to the question of the sort of consumer safety test. But what about here, what the consumer is really meant to understand about the product, but can't really, because it's an AI system that that contains complexities that really you would think that would be quite difficult for the consumer. And then it does, of course, bring in the foreseeability issues that Travis mentioned as well. But just before we open up to discuss it in a bit more detail, I just want to make the point as well, though, that of course some of these products are going to reduce safety risks, because potentially they might let the consumer know when there's an issue. There could be action taken remotely with a safety update or some other sort of fix, and preventative action could be put in place. And so there's a real balance between obviously ascertaining your sort of risk profile and the liability risks that you have, but also, as we said, the innovation and the development of products that are going to improve consumer safety and improve sort of user experience. And I think the final point I just wanted to make, setting the scene, is that I think it's important to note as well that particularly in the UK, and I think the same for the EU and probably the US, there's been very limited number of reported cases in relation to liability issues arising from these sorts of products, and particularly home smart products. So again, it is still all a bit unclear as to how these sorts of issues might be dealt with by the courts before we see them coming through in the future.
Well, I think, Katie, you are absolutely right. The development of AI will overall lead to a significant reduction in the in product safety risk. And I think the other two case studies we'll look into in a minute will demonstrate that even more clearly. What I asked myself when you spoke is, we briefly discussed when looking at the Product Liability Directive and the AI Liability Act, the question that it is so difficult for a potential claimant to actually prove causation, because claimant doesn't know what's happening in the AI. Where there is still a gap, and what's not really been addressed, is the question of connected devices that can, as you explained, come from many different manufacturers. So how would a claimant in a smart home know which of the connected devices caused whatever damage? Was it something what the sensor assessing temperature part of the causation? Was it something else? So I don't think that for these issues there's yet any help by the proposed new laws. I don't know whether that's any different than at the UK or US level.
Yeah, so in the laboratory where we've tested some of these, we have seen some interesting anomalies where, let's say we're talking about like a house AI, where as a user, you give it an instruction to say, hey, I want to run the dishwasher and the washing machine in the middle of the night because that's better for the power grid where I live. So throttle back on power during the day and run these things at night. But then the AI, without any instruction, decides to throttle back on the thermostat. That might not be a problem if you live in a warm climate. I live in Buffalo, New York, where we had 3 feet of snow last Christmas. So, if it throttled back on the thermostat in order to compensate for the extra energy going to the dishwasher in the middle of the night, that could be a problem. Or maybe I'm on vacation, I'm not home, and the AI says, oh, well, nobody's here, so I'm going to throttle it back. Well, my cats are still here. Or if it goes too low, maybe the water in my pipes will burst and cause property damage. So, it's a question of how the user is instructing or using it and to control multiple devices. This ecosystem is something that we've seen as a challenge. Connected toys I talked about briefly, but I'll say, if you look at toys and robotics together, what if you had a robot where the AI was essentially learning how to play and customizing its play based on the interactions that it's having with children, and the children think it's fun to knock stuff over. So the AI learns, oh, it's fun to knock things over. And then, the children are off, and then now, mom comes in the room and lights a candle, and the AI thinks, oh, mom's going to think this is great. I'm going to go knock the candle over. So it may not be something that was programmed for it to do, but because it's adapting and learning, a new hazard has been created based on what it's learned and how it's adapted. And, is that the fault of the children for teaching it to knock it over? Is it the fault that the programmers did not anticipate that, hey, this is fire, don't knock that over? So it really raises a lot of questions about where, sort of the responsibility is, or how to prevent that, whether it's a house AI that needs to understand all these things that we're not telling it that it needs to know, or specific control of devices that could create a hazard where it's not aware that there's a hazard. It just thinks it's playing and it's creating a hazard in the process. So there's a number of these, I think, when we look at these case studies that raise questions about, where would that responsibility be? Is it the user, giving insufficient information, or is it the manufacturer, or is it in the software, or is there something else that's going on that's ultimately responsible?
I completely agree, Travis. And I think when you look at the consumer safety expectation test, which broadly in the EU, UK and the US is the same, in that it's an objective test as to what should a reasonable consumer expect, the sort of overall safety to be, foreseeability is an absolute key element of that. And so, should manufacturers be really looking at their risk profile of their product where it's connected to or involves some sort of AI or connected device, and as you say, could have an impact on another product, how wide do they need to go with that risk assessment and that sort of profiling? And I think that's a new step that businesses should be thinking about in the supply chain, and will absolutely sort of widen that overall risk assessment that they do in relation to specific products.
Shall we move to the next two case studies? Yeah, I think in particular diagnostics imaging is a huge field for the potential use of artificial intelligence. And I think it's precisely one of those fields where it can lead to a tremendous improvement in safety, in a sense that basically what an AI can do is review, check, assess an unlimited number of pictures of a patient and compare them against an unlimited number of pictures of other patients. It can still make an error in the assessment of a certain situation, for example, by comparing a picture of a patient against a falsely classified picture in the database or whatever else. But simply by using the huge amount of volume that is potentially available, many more situations, illnesses can be detected, and so by that much can be improved when it comes to the patient's experience. For sure, I mean, many physicians, if you ask them, will say, well, it's not only comparing data, you have to have a feeling for what's going on. But on the other hand, AI will at least probably in the immediate future not replace the physician who is looking at the pictures himself or herself, but in fact be in addition to that and be complementary to the human factor. Nevertheless, there can be damages, and on the other hand side, I think at this point, what we have seen or what we've been discussing as a proposed regime in the European Union could be very well suited to deal with these issues, in particular because the causation question is very relevant. Because if an artificial intelligence is comparing an unlimited amount of pictures against an unlimited amount of picture in a data set, then it's completely impossible to find out which pictures were wrongly designated and caused the AI to come to an erroneous decision. So that is probably something which is probably correctly addressed by shifting the burden of proof.
Yeah, I would add as well that the traditional regime very much comes into play in the context of healthcare, medical devices, pharmaceutical, and many of the sort of main product liability cases that set the precedents and the law in that, certainly for the EU and the UK, arise out of that, and same for the US. So I think the shifting of the burden of the proof and the putting on the onus on the defendants and really the manufacturers, who are still most likely to be sort of the first target in terms of actually giving over and handing over technical information in relation to these systems, I think is an enormous shift and will be really quite fundamental. And the same for self-driving as well, which I know we'll just very briefly, at least Travis will just briefly talk about as we've still got some time. But it's just, I think that is such a key takeaway that, you'd now, if these proposals go through as currently proposed, you're looking at some of your most complex technical information being handed over in the EU at least.
Yeah, I mean, ideally, you're to the point Philip made, where there'd still be a human being providing the final review and the oversight, right? And in diagnostic imaging, that's certainly possible, because errors will arise inevitably. Maybe the source training data is biased to a particular gender or race or age, and then now you're diagnosing somebody that's a different gender, different race, different age, and it may miss things because of that. But yeah, with the self-driving cars, it's a different phenomenon. I mean, we're designing things without steering wheels that are completely autonomous in some cases, and we really need to have these things operating in a way that is situational awareness is paramount with respect to what its sensors and its logic and its control over its motor systems and braking systems, in a way that we don't have that extra step like we might with diagnostics, where you still have a doctor that's looking at it that says, okay, I'm letting the tool find the red flags for my attention because it saves time and lives. But in the case of really fully autonomous cars and things like that, that's not the case. I think there's many presumptions that drivers can just let it drive by itself, or things are designed that don't even have a driver function built into it. So that has to be held to a much higher standard in terms of testing and the rigors of the kinds of things that can happen and do happen, even if they're statistically low in terms of their frequency. The impact that they have when they do occur can be quite significant. And that's a big challenge for manufacturers, because when you're thinking about foreseeable use conditions, you're generally trying to limit the amount of time and money, to things that seem reasonable. But I think we all know, even just looking back on the pandemic, if somebody had told you in 2018 it was going to be a global pandemic, you probably would have suggested, maybe you need to relax. It sounds a little crazy. But these things that are highly improbable can sometimes be highly impactful. And so when we look, going back to what NIST was saying about rigorous testing of in-domain, evaluation, that ultimately is needed. The higher you go on autonomous function, like with completely self-driving cars, it has to be held to a much higher standard as compared to something where there is still a human being that's checking the outputs and is questioning it and reviewing it.
Perhaps one issue is interesting in terms of liability for self-driving cars. The liability regime for motor vehicles, at least in Europe and Germany, is different to general products, because you obviously have product liability assigned to the manufacturer of the car, but you also have liability for the driver on fault-based systems, which may fall away if there isn't any driver in a self-autonomous environment. But you also have strict liability for the owner of the car. And that strict liability for the owner of the car comes with an mandatory obligation to entertain insurance coverage. So that really may be an answer for at least certain particularly dangerous AI-driven products, how liability questions can be addressed. The owner may have liability and may be at the same time obligated to entertain insurance coverage.
Yeah, or even an obligation for the user of the vehicle to make sure your sensors are clean before you leave the driveway, because if they're covered in mud or dirt, you may be responsible because you didn't clean it to actually cause an accident because the car didn't see something coming. So yeah, there's definitely an interesting and different approach with self-driving cars compared to normal consumer products or other systems.
Fritz, I'm conscious of time, so we'll probably just wrap up to our final slide.
Exactly what I wanted to say. So you managed to squeeze a lot of high-value information in a very short time frame. The last thing we would like to do is give the audience some practical steps to take away from the seminar that we collected. So please go ahead, guys.
Yeah, I think we'd just be very quickly. We've really touched on all of these, I think, during the course of the webinar. So, and as Philip said, in terms of the EU legislation, it's sort of a rapidly evolving development. So we would definitely encourage all those businesses who are likely to be impacted to follow those closely. We obviously at TW are following them closely, and we'll keep everybody updated. But for sure, that's going to be potentially significant changes coming down the line. And then similarly, we'll see what happens in the UK and the US. And I spoke a bit about product liability risk profile and insurance, but I think particularly there is going to be some reworking that needs to be done at the sort of R&D and risk assessment stage in terms of trying to foresee and predict what sort of additional hazards and risks your products will pose and how you will mitigate and steps you'll take to try and prepare for those. And then I think the last point, and I'll just turn to Philip and Travis for final words, but is this point about the new disclosure requirements that are potentially coming through for EU. And as Philip said, in other court systems we've been used to discovery in the US and disclosure in the UK. We are stuck with it, and we have been for many, many years, and it's an enormous process. But it is really important for those manufacturers who are going to be caught by the EU regime to take a closer look at what those existing sort of document retention policies are and what steps they could take to preserve confidentiality, trade secrets, particular technical information. But I think, Philip will probably add to that, but there's a lot that businesses can do to prepare themselves if they are going to be on the receiving end of a court order requiring them to disclose a lot of technical sensitive information.
Yeah, and I'll just add that when you mentioned R&D, that some of the leading brands that we work with, are taking an approach where maybe the algorithm is locked prior to release into the market, treating it much more like traditional software. Here's the version we're putting out there. We don't want it to evolve and adapt and be too autonomous. It has already been tested. It's been confirmed as okay. And then they're working in a controlled environment on the next iteration and looking at the variables that can adapt, and then releasing it like a software update, as opposed to letting devices in the field have too much adaptability or autonomous function based on adaptability. So that's something that I think might be a best practice that we've seen where that's practical and makes sense with respect to products and systems.
Any final words?
Well, probably not pretty much. I think everything has been said by Travis and Katie. Yeah, I cannot stress enough, in particular for German continental European clients, to look at document retention policies and disclosure processes. That will be a huge factor potentially in the future, and there are means to prepare for that, in particular by retention and how you find documents, etc., and actually how you create documents as well.
Great, many thanks, guys. So for bringing up interesting topics, like I already said, lots of information, lots of know-how squeezed into the short time frame that we had. I think it was very valuable. And I also want to thank the audience for bearing with us and being interested in the Tech Me Up session. Last thing I want to say is next session is on 12th of September regarding level-based transparency and fairness, how to threat GDPR needed. So now I'd like to say thank you very much, everyone. Have a good day, have a good rest of the week, and looking forward to speaking with you. We'll answer the questions that came in. Thank you very much for that. You'll receive the PowerPoint, and goodbye. See you soon.
Thank you.
Thank you.